every policy. And so we picked a few this evening that connect to Mr. Weaver's work because there were a few in the PNN that also connect to his work. So, Mr. Weaver, I'll defer to you.
Sure. Thanks, Dr. Russell. Good evening, everybody. So we have some minor changes to 606, which is just to simply update the information in the back about what the cost per bill is as it was changed. We do this once every 4 or 5 years to reflect the changes in the current rate. Remember, the rates that the school board just approved last month will not take effect until July 1st, 2026. So this is necessary for us to update this policy at this time for 606. 702.1 is a relatively new one, so very little changes, no recommended changes to that. That matches to all of our normal peer groups that we check. Items 703 and 704 are long-standing policies going way back to 1994. There's very little changes with those as well. And we do check our peer groups. They are pretty much identical. Item 709, the only recommended change is to change from the safety and security person to recognize Chief Millers as the PV's Chief of Police. So those are the changes and recommendations and the reasoning behind those 5 items at this time.
Okay, are there any questions, comments? Okay, seeing none, thank you, Mr. Weaver.
So we will move into the PNN section, and we have 2 PNNs that we're working with from late at the end of '24. We'll start with policy 005, which refers to board organization, and there are just a few updates to this policy that I will call out for the board. And you can see some of the notations here, but there are 2 primary, sorry, my apologies. There are 2 primary changes. The first one is this green statement here: officers of the board may only be removed from such office during the designated term of office after receiving notification of the reason for removal and the opportunity for a hearing before the board in accordance with applicable law. That's been added by PSBA. We are recommending it be incorporated here. And the second statement is above resolutions. Appointees of the board may be removed from such appointment in accordance with the terms of a contract or provisions of applicable law. So these are the 2 major changes. There were a few other wordsmithing that occurred throughout, but these are the 2 major changes that were recommended by PSBA, and administration also recommends them.
Quick question. If I may, it says in the notes associated with the policy, policy was updated to reflect a recent court decision that found PA law establishes that board officers have a property interest in their job as an officer of the board. I'm not familiar with the term property interest. Can you clarify, elaborate? What does that mean?
I think it's a great question, Dr. Weston, and I'm not certain without looking up the PNN. Let me get back to the board on that and what PSBA was referencing.
But fundamentally, you have a constitutional right in your board position from which you cannot be deprived without due process of the law. Same as PC or house.
So the property interest is referring to your rights.
You just think of it as a right, but it's a property interest, so an ownership interest.
Okay.
So nobody can take it away from you. The government cannot take it away from you without due process of the law. And same property interest in a job, in a contract. If you're a contract employee. Right. Yeah, that my mind flashed there too instantly when I saw that, just in terms of Pennsylvania, right? I think all of Pennsylvania is a volunteer school board. So my mind flashed there as to what their reasoning might have been. I haven't read the case, but it essentially says it's a job. and you have a right in that job.
Were there any other questions? And we'll just get documented clarification on that item.
All right, so I'm going to shift now to Mr. Moran to talk a little bit about 308 and some updates to the employment contract and board resolution policy.
Okay, thank you. Policy 308, the premise of the changes are to align better with school code, ensuring that our practices for administering contracts to employees, from administration to professional staff members, are appropriate and in line with school code. One of the areas that we had in place with the previous policy was to provide contracts or agreements to temporary professionals, including long-term substitutes and extended daily substitutes. That is not required by school code, and so for those reasons, we included a new updated policy that does remove that language. We still provide individuals what the terms of their employment will be for an extended daily substitute or long-term substitute position. However, they will not receive an actual contract based on the new board policy, or based on the changes being proposed for the board policy. In addition, we want to clearly articulate that as a temporary professional employee, which is your first 3 years, so it's before you're tenured, that those individuals are not to receive a contract until they become tenured or a professional employee. So again, this board policy is to clearly articulate that they'll receive a term of employment. However, they would not have an agreement to assign until they receive tenure. The updates to the policy also are to identify the requirement of a 60-day notice from professional and administrators upon their separation from the district. That is a requirement by school code, so we wanted to make sure that that was clearly articulated in the updated policy. Questions?
Yeah, I just had a question about something that was in the original policy, and I don't really see something in the new one. It might be related to what you were just saying. I guess it's under guidelines, 1, 2, 3, 4, 5, 6. It was the 6th paragraph under guidelines. It said the terms of a collective bargaining agreement may supersede the specifics of an individual employment agreement in certain areas of conditions of employment. And I was just curious if you knew kind of why that was in the original policy, and it doesn't seem like there's an equivalent in the new language. So I was just curious how you saw that and what that might have been about, like why that was spelled out before.
Yeah, I'm not certain as to why that language was included in the policy. There isn't anything in our collective bargaining agreements that would be in conflict with school code.
Okay, yeah.
So from my perspective and then from legal, it wasn't necessary to include that because it's not part of school code.
Okay.
But there's nothing in our agreements right now that supersede school code. So if an agreement said we're requiring our teachers to give a 90-day notice, for instance, that could be something that supersedes the 60-day minimum requirement in school code. Our collective bargaining agreements do not include that.
Okay.
Does that make sense?
Yeah.
So I think perhaps maybe that's why it was included, if there was a difference with the collective bargaining agreements.
Yeah, I wasn't sure if that language would have related to like hiring practices or something, like to say that that maybe the district couldn't just do what they want if there is a collective bargaining agreement in place for salary or something like that. I wasn't sure if that's what it was leaning toward, but
It doesn't reference salary or compensation, but more so the term. So the term of employment.
okay. Okay.
Any other questions? Okay, thank you.
ESBA updated policy 823, and they removed the reference to naloxone throughout and replaced it with opioid antagonist. So they generalized the policy, and we have incorporated the changes and done the same. So you will see throughout our policy, there is an updated definition of drug overdose that was incorporated, as was a definition for opioid antagonist, and then throughout, you'll see where that phrase replaced naloxone.
I guess my only, for ease of understanding for the layman, I see how on the agenda it's noted PV title naloxone with in parentheses. Is there any value to including that parenthesized just as a point of, I know that that's a brand
Right.
name, but just so folks understand what a opioid antagonist, what you're really talking about there.
They would make the connection.
Right.
I think that is certainly fine. If the committee agrees with that, that might help people to recognize it, understand, if they don't.
Branding wise, they've done their job in associating what that is.
Right, that's correct. Okay.
Narcan, right. Right, but it's, at this point, it seems like it's synonymous, right? That was my only feedback.
Okay, so we can incorporate that title before bringing the policy, I presume, as long as the committee's in agreement to first reading. Okay, and I should have asked around the other policies up to this point, are there any questions about moving the policies we've discussed to first reading? Anything we've touched upon at this point? Okay, we'll note that. All right, then moving on to policies 610, 11, and some procurement updates. I'll again turn it back to Mr. Weaver.
Thank you, Dr. Russell. These three items are formalities. As notification provided by the PNN, we have updated our procurement guidelines in association with the state laws and regulations. Nothing about the language itself of these policies changes. However, the total dollar figures that we are now looking at for procurement and bid quotation thresholds are $23,800 and between $23,799 and $12,900 we need to have at least 3 phone or written quotes, and then below the $12,900 we can do single source. So it is wise and appropriate for us to pass these. These are not a board approval so much as just simply changing some of the dollar figures as driven by state law.
Any questions or comments there? All right, Jim, thank you.
Thank you.
Okay, we have a few local policies that we just wanted to touch upon. Policy 238 references parent of record. And there was a question actually raised by our administrative team, and a revision has been incorporated to clarify that both parents do not need to submit a copy of a custody order to the school district when there is a custody order. The wording seemed a bit confusing, so the effort is to clarify that. So that's the revision that's been incorporated here. It's the duty of one or the other parent to submit a copy of such an order to the district. Any questions on that one?
All right.
Okay, 810.3, we'll go back to Mr. Moran, school vehicle drivers.
Okay, thank you. The purpose of this policy revision is to expand the definitions that we have included in what is considered a covered driver. So we want to expand that to include drivers or operators of school equipment, primarily going to be vehicles or equipment that is not used to transport students, such as heavy machinery that we may have within the district, or a van that might be utilized for mail run compared to using a van for transporting students to an event. Also including contracted transportation providers in this revised policy. And the other primary focus was around ensuring that we had a policy that clearly articulates the need for running what's called a motor vehicle record on any individual who is going to utilize a district vehicle as a covered driver. So we wanted to make sure that we had those procedures part of this policy that includes not only individuals that are going to be driving students, but also individuals that are going to be operating district vehicles, such as our police cars, again, heavy machinery, school mail van, and vehicles as such. Those records will be conducted pre-employment, and then also we would include those for an annual basis to ensure that we are running driving records for individuals using school vehicles, and then also upon if there was an accident and we needed to then run a motor vehicle record on an individual, making sure that we had that part of the policy and then administrative regulation. The other area that we really wanted to focus on for this policy was ensuring that we had procedures for drug and alcohol misuse. And if an individual was suspected of drug and alcohol use while driving a vehicle, that we had procedures in place that we could have them tested. So that is not part of the current policy, so we wanted to make sure that that also is part of this policy. Drug and alcohol testing would be utilized for individuals if there is suspicion that they may be under the influence and or post-accident. We would want to ensure that we're running that test, very similar to what you would do if you had a bus driver who was in an accident. That is a requirement.
Mr. Moran, would you be able to speak to the way that this reads and what you've said has to do with employees of the school district as they operate district-owned vehicles?
So this would include volunteers as well.
But there's nothing explicit that notes that unless I'm missing it. I don't know if there is a value. I think there probably is a value actually to including that based on conversations about coverage and oversight to volunteers that are operating school vehicles. I know that's a question that's come up a couple different times this year so far.
Yes, so as I was speaking as though they were employees. However, policy listed as a person. So it would include employee or volunteer, anybody that is utilizing a school vehicle. So they'd be considered a covered driver.
Right. So, but that should be verbal.
Explicit.
That should be explicit, I think.
Yeah, that's an area we can call out.
Because I think that the district, I mean, this affords district oversight to employees, which makes sense, but I think the district also does need documented oversight for volunteers if they're acting on behalf of a district group.
Correct. So if a non-employee or volunteer were to utilize a vehicle, we would conduct a motor vehicle record check.
The same qualifications.
Same qualifications, yes. Yeah.
Okay, so we can incorporate that.
Mhm.
And we have something to point to then.
Yes.
Should a driver want to be a volunteer?
Right.
Mhm.
So we'll update that, and we can share that in advance of the next board meeting, where otherwise, are we comfortable with this going to a first reading?
With
Okay,
those
so-
incorporations.
Yep, we'll update that and incorporate before that first reading, before it would appear before the board. Okay.
Thank you.
Okay, thank you.
And the last policy for this evening as part of our local policies would be 828, fraud. Mr. Weaver.
Thank you, Dr. Russell. So this is a new policy for Perkiomen Valley School District and is a recommendation from the state's ESSER monitoring process. We do have fraud mentioned throughout policy 626 currently. However, the recommendation from the state, the team that monitored us, is to specifically call it out in a separate policy. Indeed, other school districts do have this policy, 828. So we looked at what our peers are and what the recommendation was from the monitors, and the policy is in front of you tonight. Again, it's a new policy. It sets out and defines what fraud is. Again, we thought everything was in order in various spots. We certainly felt strong enough with those other items. However, this certainly emphasizes and calls out fraud specifically in case if anything should happen. It defines it, and then it talks about ways to prevent it, and it also talks about the process in place should fraud be brought to someone's attention, how and where that goes, and how the process works. It is a very clear policy, and we agree with the recommendation to get that in there and clarify that. It's a very important item for us from a trust perspective with our taxpayers, and we agreed with it.
So the only question that I personally have about this is around the piece of confidentiality. I'm just wondering if there should be incorporated language about I don't know how to say it, like oversight to the oversight of maybe like an impartial party or. Do you know what I'm saying?
Yeah, I think it's integrity. It's about the integrity and making sure.
Right.
Yes.
So, I mean, in full transparency, I just feel like if there's going to be an investigation into fraud of this nature, that the spirit of the policy would be to have it be independent.
Yeah, third party. Yeah, because the superintendent could be involved.
Hypothetically,
Right.
you know,
I understand.
a collusion.
Sure. We can check that out and bring it back.
That would be my question. I mean, I feel like that's the type of thing you hear about if there's
Sure.
something under the.
And the term, at some point in time, it crosses over into that potential whistleblower.
Yeah, it just seems as though, maybe solicit, like the solicitor steps in. I don't know how that would, I don't know what the language would be.
Okay.
I just am wondering if in the spirit of what this is trying to achieve, maybe it actually be an impartial review of the facts.
We could certainly take that back and look at that. Yes.
Yeah, we'll do that, and then, again, bring it forward to the board, either for a first reading if we're comfortable with the corrections, or to the next policy committee meeting.
I mean, I would ask that it come to the next policy just for further discussion. Does anybody else have an opinion about that? Mr. Keenan, do you have a opinion there?
Trying to figure out if there's an answer to that, at least conveniently, because certainly believe that it is important to have independent review, so that in case, not that we would imply that maybe the superintendent or the business director or somebody would be involved in this, but they could be, and you never know how deep it could go if you find something.
Right,
So,
the policy should stand for the future.
um,
Yeah, right, as well.
but at some point you have to put your faith, in somebody.
Fully, absolutely.
So I don't know how much we can do to be independent, or how great it would be to have a law firm, involved in our private, personal, financial administration. So
Yeah. All right.
I thought on the law firm.
Mr. Liggett, Dr. Weston? Nothing?
Yeah, I guess I don't object to it, I think you would have to figure out how to work it in here to where the independent, whether it would be an independent authority that we bring in an outside people, or that we just want a spirit of independence in there. Because reading over most of the policy, it seems pretty clear as far as how it asks for an investigation to go, with the superintendent being at the lead of it, or the president of the board if the superintendent happens to be the target. Not saying he would be. And I think if we were to say that we want to move this then to a third independent party, I think there would have to be a lot of thought behind that as far as who would initiate that. Would this be in all cases of fraud? Because it seems that some of the simpler cases would be handled quite well with this policy.
Maybe there's
So
a threshold or something like that. Okay.
Maybe. I think we would definitely need to give it a little bit more thought before we just insert
Language.
this language
Yeah,
in
and I don't
here.
want it to be without purpose, but I just feel like there should be some more transparency in terms of the burden of this falling on one individual.
Well,
That's all I'm saying.
the other question is then, as far as transparency, is let's say there's an accusation of fraud. At what point does transparency start? Because that person, until they're, quote, proven,
Right.
has a right to privacy as well.
Well, that's where
and
I
the
mentioned the
district does. So,
confidentiality piece of it,
yeah,
right.
confidentiality, yeah. I think it definitely deserves another look over
Okay. So
as
we'll
far as
discuss
that's
again.
concerned.
Perfect. Okay, I agree. We'll discuss again in February. Thank you. Good stuff. All right, so that's our last local review. And that brings us to closing items. Meeting minutes will be posted following the meeting. We have next meeting dates. Our next meeting is Monday, February 10th at 6 p.m. So notice a video disclaimer. It did start a little bit after I called to order, but it should all be there. And with that, I adjourn, and we will see everyone at 7 p.m. for our business meeting, right? Thank you so
Thank
much.
you.